Hi, welcome once again to Legal Matters. I'm Debbie Moraes. Legal Matters is the program that's designed to address some of the critical issues facing consumers and businesses today. We like to say it's legal information, it's practical information, and straight talk about a wide variety of topics. Once again, we have with us our lawyers from Audette, Bazar, Cordeiro Grasso Law Firm in East Providence, Jackie Grasso and David Bazar. Welcome. In past segments, we've been talking and focusing on your money matters. In view of the slow economy, so many home foreclosures have been continuing. The Obama administration has been trying to help out. Rhode Island has had an additional infusion of cash that they've made available to homeowners. We hope that that's helped you. Today we're going to be talking about a timely and a recent topic which was raised based on the recent verdict from the Casey Anthony trial. It prompted people to discuss the idea of jurors. What do they know? How prepared are they? What are their qualifications? What are they thinking? So I think we probably need a little bit of a primer about that, and we have our legal eagles here to address that. What is it? What are the requirements to be a juror, whether in Rhode Island or Mass?
You just have to be a registered voter, basically. They pick it from a pool. It's random.
The Superior Court in Rhode Island, for example, which is the primary trial court with jurors, there are some exceptions to that. Family court has a limited jury jurisdiction. But the Superior Court creates, based on the Providence County, Kent County, Washington County, Newport County, and Bristol County, registered voters and so forth, their list of potential juries in the jury pool. And then from that list, notification is sent out to the jurors if they've been picked to come in and become a jury, potential jury member. You're in the pool. What we often get questions of from people is whether or not they can opt out and what are their rights to opt out.
Only if you have an illness and you have an excuse from a doctor,
Right.
But generally speaking, no, you can't opt
Yeah.
out.
Or maybe you shouldn't. It's your civic and
It is
community
your
Yeah.
civic duty.
And that's what we tell people when they call us about that, is we encourage people to fulfill their civic duty and be on the jury if they're called to. There are some exceptions in the statute as to who can be exempt. Lawyers, for
Yeah,
example,
yes.
are exempt. Other folks that have other reasons to be exempt can put in an application for an excusal, but again, what we usually see with that is it's more of a postponement than getting out.
Sole proprietorships, there's only me, only I can take care of my business, and I just can't do it right now. And it happened to me one time, and I can remember that they said, yes, but you can have this deferral once, but you will be called next pool. Is there a difference? There are two, I guess, main kinds of cases that people will serve on, criminal and civil. Is it from the same pool that they draw, and what's the difference?
It could be. It just depends on what's on the calendar that day. So they might call in as many as, 25, 30 people.
Yeah, or into that particular pool, but there's more, actually, that are called to court. And they sort of changed the way they do it. It used to be you could get called in, you could sit there for 2 weeks and never get on a jury. Now what they do is they call you in, and it's usually like a 2-day window, and you're sent out as the judges who are now sitting, impaneling juries, so to speak, for each trial comes out. You're called in, and you might be in a bigger pool, and then you're brought in front of the judge and the attorneys and the parties in the impanelment process, and you have that opportunity within those 2 days to get on a jury. If you don't get put on a jury, then you're allowed to go home.
What are they paid? It's nominal, I understand.
Yeah, it's very nominal.
$5 a day?
I'm not even
$50
sure
a
the
week? I know
number.
they pay for your parking.
Yeah, and depending on where that is, that's got some value.
In Massachusetts, anybody who's in a jury pool, they're instructed via letter to contact an 800 number to determine if they have to be in court. So I'm assuming if cases settle or if they're not needed, obviously, then they'll tell you on a recorded message, so you don't have to go and spend an entire 2 or 3 days there waiting to be called, because I've had that happen to me.
Yes. And if you're called into Providence, for example, you ask civil, criminal, you don't know what kind of case you're going to get until you're brought down in front of the judge. Then the process would be the judge will introduce the parties, introduce the case, the lawyers will introduce the people who might be witnesses and what the case is about. And then it could be a criminal case or a civil case, and you find out about the case when you're brought in front of those people.
I know that you've served as judges, but as I understand it too, jurors, for the most part, when they're given their charge, they become judges. They end up being the ones who are the deciding factor, and at times they're not able to be even challenged later. So it's brought up so many questions about, and I hope we have time to discuss this, but should there be a professional jury versus those who are just picked among my peers or someone's peers? What kind of preparation goes into someone being selected for a juror? I know that they're told not to discuss the case. Some of them can't leave their homes. What are some of the things that people need to know if they're going to be jurors? What are the qualifications or prepared
I think
steps?
Anybody can be qualified for that matter. I don't think you can pick and choose ahead of sending out a request for a pool. But as long as somebody is competent, fair,
How do you get to determine that?
not biased.
The lawyers
They
and the
ask.
judge determine that through this process called voir dire, where the jury panel is brought in and questions are asked of the jurors that, for example, the lawyer will introduce his client and the names of witnesses, and does anybody know any of those people, and is there anything in that background that would make them unfair? So there's a lot of opportunity to try to ferret out whether or not the people who are being proposed to be jurors will be fair and unbiased. But going back a little bit, the history of juries actually in the United States and our common law is all based on the law in England. And the jury system has evolved from going back to the Magna Carta, when the King of England was challenged with his absolute rights, and he picked the judges, and the judges made the determinations, and if he didn't like what they did, they removed the judges. Well, the right to be judged by a jury of your peers flows back from that. And in our system, we want not professional jurors, but people who are from the community, a jury of your peers, as we call it, so that they're bringing their common sense and the common sense of the community to bear on what the question is before them.
I don't really want to jump the gun on this, but I really do want to discuss the issue of jury nullification. I know people have talked about it for several cases, whether it was Vietnam, and the draft card burning.
Rodney King.
O.J. Simpson. Casey Anthony. And maybe you should give a quick, broad brush stroke description about what jury nullification is about.
Jury nullification, simply put, jury does what they want. They make a decision to acquit the defendant despite the evidence that's before them and despite what the judge instructs them. So if you use O.J. Simpson as an example, some seem to think that that was more of a statement based on, I hate to say it was race-based, but it was more a statement based on being fair to African Americans versus was he really guilty, instead of looking at the evidence before them. So in that case, that was a good example of jury nullification.
Yeah. And the's a whole history of jury nullification.
It goes back to
Right,
Magna Carta.
and going back to England. And when you go back to England, there was a case, I heard about this in the course of studying in law school, so it goes back a long ways for me.
Yeah.
But it was something along the lines of a fellow was charged with killing another person, and it was an accident. And the law at that time in England was if you killed the other person, then you were going to be killed yourself if the state, so to speak, the government could prove its case. So it was at that point in time in England that either the jury said they proved the case or the case was not proved. Well, the jury couldn't say the case wasn't proved because it was clear that the other person had killed the other guy, but by accident. So the jury came back with a finding that we use today, not guilty. And they said they always had the right to find not guilty. It had fallen out of favor, but now that was jury nullification.
Yeah.
The government proved its case, but the jury still found that fellow not guilty.
Well, it's said that the jurors are supposed to be
appealed.
And can't be appealed.
That's an important point.
It's very important.
They say that when a jury is charged, the juries are supposed to be the best judges of fact. However, a judge is supposed to be or the court is the best judge of law. My understanding about jury nullification is that the minute someone says, I don't think the law is right, that's one of the reasons why they can say, I vote not guilty.
Yeah.
But they're not then judging based on the fact, they're judging on the fact that that law seems not to be right, dating back to the king or whatever. And he might have been wrong by saying what I say is just and only true. Why is it now that there's such debate about, or I guess questioning of judges who will not allow or will not say to the jurors before he dismisses them for deliberation that you are entitled to make that judgment, and actually you are entitled to be aware of what jury nullification is. They seem to not want to go down that path.
I don't think it's the judge's responsibility to tell them that. He or she's responsibility is to issue a charge to the jury, give them instructions, tell them that they have to make their decision based on the evidence that was presented before them.
Right.
I think he would be breaching his duty if he
Right.
said to them, you have the ability to ignore everything that I say, and you can make your own decision, forget about the evidence, forget about what happened in this court today.
So the American system
That's not a system.
of jury trials has evolved to this point. Jurors are responsible for making the findings of fact. The judge is responsible for instructing the jury on the law. That's our system. Now, jury nullification has been appealed and upheld by different courts in the United States, but also, which is what has been appealed, is whether or not the defense lawyers have the right to ask for an instruction on jury nullification, and whether they can even argue it. And there's case law that says you cannot instruct the jury's members on jury nullification, and the judge does not have to and should not give that instruction because he's responsible for the law. So if the juror on its own wants to take that up, they can, but you can't tell them they have the right to do that.
That case law that you're referring to, David, is that something that is cited state to state? Is it something that lawyers might share with?
Is that a Supreme Court
Is that a
case,
Supreme
US
Well,
Court?
Court?
there's
I think
definitely
it's a
Court
US
of
Supreme
Appeals,
Court.
but I think it has been to the Supreme Court
Yeah.
before.
Okay, let's speak to what jury preparedness is about then. If a jury is supposed to do what it's supposed to do, doesn't it make sense that they should have an understanding of such history, such as it stands, what their options are, including that if they think that this law is not right, that they should not be voting guilty because it means someone could be sent to the death chamber or whatever. Do we need to do a better job of preparing our jurors to understand what their rights and responsibilities are?
I think, it's my personal opinion, the most important part of every trial, every jury trial, is voir dire, picking the jury. I
Right.
think that's the most important part. So it's up to the attorneys to ensure that those that are picked as jurors are going to be
Attentive?
they're going to understand, they're educated enough to differentiate between different legal issues. They don't have to have a law degree, but I think it's the most important part of.
Right.
They have to want to be there. They have to know that they have an obligation.
Right. They're an important part of the process, and that they have to understand their responsibilities in that process.
What you're describing, it sounds right, Jackie, but it also sounds that it might be a level of sophistication that I'm not so sure that most jurors who are benched, or whatever they call it, are seated. Seated, that's right. Thank you for the point of correction. It doesn't sound like that's something that most jurors are really necessarily equipped to handle, that fine power of discernment and understanding of the nuances of law. That seems like that would require, never mind a question about are you biased, unbiased. Do you understand, and there could be a litany of questions that perhaps they should go through, you say it's voir dire, to make sure that someone does understand what they can and can't do.
Well, most cases that we have don't require a lot of sophistication or understanding of technical things. It's really the jury just applying their own common sense to the facts that are being presented and making their determination. The jury nullification issues cuts both ways, and it